All right, excellent. So welcome everyone, a welcome. It seems like we have everyone from all the provinces. And if we have people from Durban, raise your hands and bring the warmth this side, because we need some temperature this side. It's very, very cold in Johannesburg. So we thought about this talk mainly because it's Women's Month, and because we are democratic, we thought, no, we're gonna do it for Women's Month, but we're not gonna discriminate anyone. Everyone is welcome, but we know it's Women's Month, and we know that there is a lot of women that are in business, and particularly small businesses. And small businesses, I think there is enough, or we can say sufficient evidence that when things go wrong, the small businesses, they keep pulling the country to the right direction. And in respect of that, it is worth giving ourselves a round of applause that we have stood the test of time, regardless of the challenges that we are in. So in short, the business workshop is about three things. One, it is our thinking that, yes, you'll conclude certain contracts, and we thought that we can share some information around the conclusion of contracts, and we could share information around tax, because we know that compliance is everything. And our big brother SARS doesn't leave a small business because it's a small business. SARS will be in your case, whether you're a small business or a big business. So we thought it would be worth discussing that. And then we thought as well that, how do we get customers? How do we tell our customers who we are, what we sell? What is the value of the things that we sell? And we thought these three things could actually be critical for small businesses to actually have a conversation about. So this today is not a lecture, it's a conversation for everyone to participate, which is why you will be welcome during the session to put in your questions on the chat box, on the live Facebook, alternatively, right at the Q&A. You are welcome to reserve your questions for that. So by way of introduction, my name is Yolelwa Sikunyana, and I am the owner of Sikunyana Incorporated Attorneys. This is a firm based in Midrand, servicing mainly SMEs. And I know that when we say SMEs, we don't know who we are talking about exactly, but we are talking about the firm structure of this country, and it has been proven, as I've said. So we're talking people who are thriving every day to make something of themselves, to create employment for young people and other sectors that have been in existence but have never created so much employment. So I will be covering the contract side, and mainly in principle. Usually we go in depth with all the clauses in contracts, but in principle, we just want to bring a picture of why we have to conclude these contracts and how do they secure our investments. And the second phase will be Molen. Molen is a CA, and she practices in Midrand as well as a chartered accountant. She has her own firm, and the idea today is that she's going to share with you the compliance issues around tax. Why is it important for us to comply with tax, and what are the loopholes? What are the things that you need to look out for? And you can engage with her, and what are the services that they are actually offering. And Lauren Campbell is a social entrepreneur. When I say social, I know we talk big things. These are people who make the difference in the world, and they look after us entrepreneurs who are in this thing for profit, and they say, okay, listen, let's do something for the society. So they encourage us all the time. So Lauren is a director for AIF, which is an NPC that helps small businesses into the development space and support. They give support to the small businesses, but she will introduce herself and will give more about AIF. So without wasting any time, we can then prepare to start this session. I will share the screen. So if you have any questions, I think you can just drop them on the chat box, or you can have your hand raised, or you can wait for the Q&A. Okay, Lauren, is my screen visible?
It is, Yolelwa. You just need to change to full screen.
Okay, excellent. There we go. So usually this part of contracts is followed by an ethics and anti-corruption session with entrepreneurs, but we're not going to go through that today. So please don't panic and think that we're going to be here for the whole night. We're only going to talk about the contracts today. All right. So now, as entrepreneurs, the critical question for us is to say, if we conclude business with anyone, how do we make sure that the people that we do business with are going to do the things that they say they're going to do? They're going to pay us on the days that they said they're going to pay us. You know, they are going to perform, in essence, in accordance with the contract. Because you may have borrowed money to invest into this business, but you're just not sure if this person is going to deliver. So that is what we call investments. So whether you've got an idea, whether you've got a proposal, that is an investment that you intend to commercialize. But in the event that that business you intend to commercialize, but you do not conclude a correct contract for it, that is to protect your interests, then that investment is exposed. You are also exposed as the owner of that investment. So the question today is, how would you use a contract as a legal framework, alternatively as a tool to secure your investments? So first of all, as I've said, the contract will detail the legal obligations and the expectations of parties. And most importantly, things that people don't think about is how will we resolve negative situations? Because when we conclude businesses, remember, we are happy, we are jolly, and nothing is going to happen because we know each other, we've known each other at the university or whatever the case is, or we trust each other. But the question is, if things go wrong, what are we going to do? And that is something for many, many businesses to think about. But why? Why a contract? Why is it important that we conclude contracts as businesses? First of all, why a contract? Firstly, is that it's a legally binding agreement between two or more parties. So contracts are not limited to two people. They can be between 10 people, 5 people, or even companies. So when we say parties, we also represent what we call in law juristic persons. These are companies. So you don't have to be an individual only to conclude a contract, or you don't have to be companies. An individual can conclude a contract with a company can conclude a contract with an individual, and vice versa, and a company versus a company. So when we are individuals, there are certain rights that accrue to us as individuals. And as juristic persons, there are certain rights that accrue to us. Juristic persons refer to companies. And I want to draw the attention of directors, particularly to the Companies Act, that whenever you conclude a contract with an individual or a company, you need to understand that you are representing a company, a juristic person. So this is not you concluding a contract. You are concluding a contract on behalf of a juristic person. Now, where things go wrong is that directors do not resolve, they do not hold meetings as they are required and resolve that they are authorized to represent a company. And I want you to take a note, before you conclude any contract, you need a resolution, because you are concluding a contract on behalf of a juristic person. So just because the company belongs to you, you are the director of the company, doesn't mean that you are authorized to conclude a contract. So the company must authorize you, and that happens through a resolution. And please record resolutions, record minutes. If you have more than one director, if you talk about something and you resolve, you're going to take a loan in F&B, please, you need to record that, because once that financial obligation, it is proven that it has put the company under financial distress, there are consequences for that. So you'll need to say, we considered 1, 2, 3 as directors, and we felt that this is a good decision for a juristic person. So we said that this is a legally binding agreement, whether you are an individual or a juristic person. Now we want to say to you, all the duties of these people will actually be detailed in this agreement. Now, have you ever heard of something that is called an NDA? And I want you to hold on to the word. NDA means non-disclosure agreement. So a non-disclosure agreement, usually we get it as an initial contract. And I want you to understand the terms, and we will cover them just next in the next slide. When we propose NDAs to each other, we actually establishing an initial contract, an initial contact between parties. We don't know each other. That's why when you are in business, you don't need to do business with people that you know. And the understanding is that, yes, I don't know you, but I must do business with you. But how can I secure myself? This will be through a contract, which is a critical document to secure an investment when you're dealing with people you do not know. So when you sign this NDA, the idea is to say, I'm going to disclose some information to you. And I'm also disclosing some commercial information to you. So let's protect the terms of our engagement. Because if you tell my competitor about what we are trying to do, my competitor can circumvent me. So I'm restricting you because I'm explaining to you what I need you to do for me, and you are telling me what I need to do for you, but that must be sealed. Be sealed to the extent of Cyril Ramaphosa's funding documents. So that's the sealing we're talking about here. Zip, nobody tells anyone anything. And most importantly then, Loli, I need you to monitor my time, right? Please tell me when I'm 5 minutes away. So the critical issue then is that the non-disclosure introduces the sealing. I'm going to disclose to you my commercial secrets. I'm going to disclose to you my pricing. I'm going to disclose to you my formulations. This is how I've done my proposal. So instead of you going to your friend and saying to your friend, my friend, just look at this. Can't you do this? Don't you think you can do this? And this is what happens to SMEs. And that is why I have selected to talk about non-disclosure agreements, because this happens a lot to SMEs, where SMEs go pitch, because we are people who are enthusiastic by our nature. We go pitch, we go do proposals, we submit proposals here and there, and we lose touch of who we have submitted proposals to. And to that extent, then we lose our ideas to people. They give them to their relatives, to their friends, and we've got no document that protects us. That is why a non-disclosure agreement is important for SMEs, because it protects their disclosure. One, that's why it's called a non-disclosure, that do not disclose to other people that this is my concept. Do not copy, do not disseminate unless it is necessary. So it restricts the dissemination, it restricts the copying. Besides the fact that the Copyright Act in South Africa protects the original ideas of people in South Africa. But when you are in business and you do business with people, you can't only rely on a copyright. You need to restrict your business partners not to do certain things, because it's easier actually to enforce contractual rights than to enforce common law rights, because the copyright will give you a private rights protection. When we talk about private rights, we talk about things that you need to go to court and protect them. The state is not going to protect them for you. So private rights you must enforce. So, but if you've got a contract, you've got a more detailed argument to present in court, because you have detailed, don't do this, don't do that. If you do this, this is what will happen. So there is more evidence for the court to work with. And SMEs have come to us a lot of times saying that, but I went to this municipality to present my concept and my concept was declined, you know, or it was ridiculed to say it's not viable. But today I see that concept being adopted through another company to the same municipality, for an example, without offending anyone who works for a municipality. So it's just an example. So all I'm saying is that should you have concluded a proper non-disclosure agreement, first of all, that's your intellectual property, number one. Number two, it contains commercial secrets. it contains formulations that you worked day and night to commercialize. And now somebody rejects it, but tomorrow their friend has a contract for that. So it would have been easier for you to enforce that contract should you have concluded it, because you would know exactly who you presented to, who you concluded that agreement with, and you could link the parties. If there's now party B who's now rendering the same service to this municipality, it's easy for you. You've got an NDA with that municipality. How did this third person know? You see, that's why contracts are important. And particularly NDAs as an initial contract to open other negotiations of further contracts. NDAs are important for that. And we know for a reason that the reason is that it is expensive to litigate. So for SMEs, at all particular times, you want to mitigate your risk of litigation by consuming legal services proactively. So you need to be in a position to review your risks, your legal risks proactively, so you prevent litigation, because litigation is expensive, and it's not why you are in business. You are in business to make money, not to litigate. So instead of you saying, oh, don't worry, you steal my idea, I'm going to court, mitigate your risk, because then you can point to the party that would have allegedly disseminated your information or copied it. It becomes easier. But what exactly is contained there? First of all, NDAs contain confidentiality of disclosing. So it will tell you, an NDA will tell you who is protecting what. Am I disclosing to Lauren, company A? Is Lauren also disclosing to me? Some NDAs, remember, there is only one disclosing party, the other is not disclosing anything. So you must remember that. Then there's mutual, then there's just one-sided NDA. And I want you, when you receive it, because sometimes when you do tenders, you will receive an NDA, but probably you don't read it because you're like, okay, it's just an NDA. You know, we just signed. You need to read an NDA, whether it protects one party or it also protects you. Because once you submit that proposal, and I've said this in other areas, that especially in the public sector, you must read their terms and conditions. There will always be a sneaky clause in their proposal papers that says, should you submit your proposal with us, we own that proposal. We own the intellectual property of your proposal. So that is why it's important for you to read carefully who owns that intellectual property once you submit it. Secondly, NDAs are not standard agreements. They are meant to be read, because if they don't protect you as the other party, then your investment is exposed. Remember, you can't work throughout the night submitting a proposal for fun. You know, that is your intellectual property. So that investment, that time you've put in, it's gone, because you're going to be sending to company B. Company B is going to say, but I've seen this from another company. So it doesn't surprise me, but you can be able to challenge it if you know exactly who you dealt with in so far as disclosing this confidential information or your commercial secrets. So the second important thing about NDAs and how they protect your investment is that they protect any type of confidential information and proprietary information. And when we talk about proprietary information, we talk about this, something that you developed with your own mind. And when we talk about trade secrets, these are the things that when we employ people, we try to protect that information from our employees. But when we give this information to our customers, we never think about it. Instead, we restrict our own employees, but we don't restrict our customers. That this is my trade secret. What I'm giving you is my KFC spice, so to speak, because KFC spice is a trade secret. If it's leaked, they're gone. So it's exactly as your concept. If it is leaked out there, you no longer possess the uniqueness. And the third part that is important is that it restricts sharing of the information. When we say restricts sharing, I can't send my friend your proposal to look into it. I can't send my relative. I can't send my boss. I'm restricted unless that person is relevant or is mentioned in the NDA that you can share with them, usually, which is consultants, employers, and stakeholders that are directly linked to the deal. So I can't just willy-nilly send my friends, oh guys, someone just sent this proposal. What are your thoughts? Because in the very same link, I am not in control of who shares what I have shared with them. So NDAs will usually restrict sharing of the people that you share with as well, which is why it specifically categorizes who you must share with. And that on its own gives you a picture of how important it is for you to protect your own investments through contracting. And I am sure I'm left with a few minutes, but what usually happens then is that we say there are standard terms in a contract, not standard contracts, and I want us to take it home. There is no standard contract. There are standard terms in certain contracts that are present in every contract, and you need to understand what they mean to you. So I can make an example now and say, in any contract, you will find the name of the parties. That is a standard term. It doesn't mean it's a standard agreement. It has to be there. Who are the parties? Parties is company A and company B. Who are they? The other is a CC, the other is a PDY. What is their registration number? Where are they based? Those are the things that must be in a contract. So literally, the contract will have about 20 to 25 clauses that will appear in each and every contract. And that is what we call standard clauses, not standard agreements. There is nothing called a standard agreement. And I think the downfall for every business, big or small, has always been to think out there, there is a standard contract. It doesn't exist. And I think that is why the NDAs are actually underplayed, is because someone thinks out there it's just an NDA, it should contain the same things. Some agreements we have learned, through the disputes that we come across, that some agreements you need to protect in the NDA insofar as discussions are concerned, not even exchanging information. Some discussions are worth protecting right from the NDA because you've already talked, you've already told the other party your commercial secrets. And that in the end exposes your investment to being stolen or to being intercepted, so to speak. Other people can take your idea and they just change a few things and add S's and R's there in the end, and they give it to their friend and they say it's a new concept. But it's time for small businesses to take their own investments seriously and to conclude the correct contract to protect themselves. So if I am correct, we are on the Q&A time, and in the next session, of course, we will deal with clause by clause, the clauses that I've mentioned, and that session will be in the near future, and we can go through them as they appear in every contract that you are going to sign. But the issue here is that we wanted you to understand the principle of contracting. Why is it important? And why are NDAs sellable as initial contracts?
Yolelwa, we have some questions. Are you taking questions now?
That's correct.
Okay, let me read you. From Raksha, we've got Yolelwa. Is your advice to ask all potential clients to sign an NDA before we share any proposals? Excellent question. In fact, that is my super recommendation, that you do that. You approach, when you approach a client, or whether the client approaches you, whichever way, it is my highly
favored recommendation that you say to that client, hi, nice to meet you. I'm glad to come and propose and do a presentation for you, or thank you for the invitation to come and do a presentation for you. In fact, herewith attached our NDA. You are welcome to give us your comments in certain clauses. Otherwise, you are welcome to sign. That is my proposal. And I'll tell you the advantage of it. One, it keeps track of who you send that proposal to. And secondly, it's going to keep track of who is linked to that organization that later resurrects with the idea of being you, when you know that the original idea emanates from you. And it's important to understand that copyright doesn't change just because you didn't sign an NDA or not. Copyright doesn't change, but it's more difficult to enforce that right out of a contractual arrangement, because you're going to have to rely on the entire act and to prove many things that you could have eliminated by merely concluding a contract with whoever you shared your proposal with.
Yolelwa, we have one from Sitembele. How do you protect or manage a request from potential customers, especially a government department, who wants to visit your operation, inspect and confirm your capacity to deliver, when he or she has not yet awarded a contract to buy or not given you a purchase order?
Yeah, well, especially with government, guys, I want you to be careful when you are dealing with government clients. Government is a different animal. So the government is highly regulated, and there's certain things that they get away with because of the high regulation that they are exposed to, and the fact that PFMA is so presumptuous that, you know, government employees will actually follow it. Unfortunately, even if they don't follow it, that act supersedes anything, including other procurement legislation. Now, what is critical about government is that their own evaluation system will at times require them to go on site and inspect if you comply with the tender, blah, 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 blah. Because out of that tender, it requires a physical inspection. So before an evaluation process is complete with a public entity, they can do anything insofar as it relates to the evaluation. But unfortunately, they can't give you a PO until such a time you have been appointed and you have signed an SLA. And I say an SLA specifically because some of the SMEs have actually conducted business with government without signing SLAs. And you can't, because government is going to tell you that is irregular. And because the PFMA says so, the triple PFA says so. So when you conclude a contract with government, make sure that your SLA has been signed. Very, very important. We will talk about letters of intent one day, but anyone who receives a letter of intent, whether it's a private company or it's government, I want them to proceed with caution. But with government, make sure you perform only when you have secured an SLA.
Next question. Does one have a leg to stand on if you want to challenge a tender where you are disqualified for failure to submit a resolution of board directors to sign the tender document while you are the sole director?
I like that question because I just said that. I said directors are representing companies. So when you don't have a resolution, you literally do not have an authority to act. So that is critical. It does not only emanate from a tender document, it directly emanates from a Companies Act, which is legislation that you must be authorized to act on behalf of the company. But insofar as a disqualification is concerned, it will depend on the circumstances. Remember that not everything is supposed to disqualify somebody. A person out there can simply request that you submit a resolution, unless in that tender document, it was specifically said that a resolution is a mandatory document. You must remember that tenders come with specification and elimination. So if it is a mandatory document to submit, you will be disqualified. And I say this again, that these days, a resolution has become mandatory because parties have been proved not to have been authorized by companies to submit certain tenders, alternative to conclude certain contracts. And that is important. Remember, whether your contract is going to hold water or not, it also depends on whether you've got the authority to conclude such a contract. It's part of the formalities or the requirements of a valid contract, is that do you have an authority to conclude that contract?
Okay, Darlene asks, is there a simple template of an NDA that you have?
Yes, we try. And this is after I have said that there is no standard agreement. So before we can even say it's a template, we want to know from a client, what is it that they want to protect? What is it that, which business deal they are doing? I could be doing a deal with the University of Pretoria, for instance. You see, when you do a deal with a state-owned or a government-owned entity, there is an act now that protects IP for collaborating with universities. So immediately when my client says, I need an NDA, I'm doing a project with University of Pretoria, I'm worried already, because you can't own IP when you do business with a publicly owned institution. So that means I need to customize her NDA. I cannot just give her a normal NDA, because I know there's law that affects her, that she will lose her rights to the intellectual property she's giving to a publicly owned company. So there is a standard, but again, I want to know. Just like a doctor, I won't say go buy Panado if you have a headache. I just want to know, what is it that you want to protect, so I can advise you on how it's supposed to be structured.
Yolelwa, Rusty asks, in small companies where one has the owner and then basic workers, who does the owner sign resolution with?
So if you are the one director, and I'm using the word director under the presumption that it's a private company. So if you are the only director, you don't need to hold a meeting. You just need to resolve. And we do have the standard resolution that we can share with companies. In fact, as a gift, I can share that with you, Loli, when you send the feedback emails, how companies can actually sign a resolution, a standard resolution. So it can either, this resolution can either be saying, I am Rusty Hugo, I am the managing director of so-and-so P2Y Ltd. I am authorized to conclude this SLA with the Department of Labor. And I want you guys to remember, resolutions must be specific. So even if it's going to be sent as a generic draft, but you must specify it for the tender that you are doing or for the meeting that you are having. If you are borrowing money from ABSA, you need to update that resolution for the ABSA money. But for tenders, you can create a generic resolution that says you are authorized to conclude tenders. And then that will be a generic resolution. You don't have to do it each time you do a tender, but make sure it has the relevant reference number. But I will share a standard resolution that authorizes directors to act on behalf of companies.
If there are any more questions, you're welcome to put them on the chat or unmute yourself and ask. We still have a few more minutes.
Oh, great. Or someone can just unmute themselves and ask.
Yeah.
Thank you so much, it's Alfred. What do you do in areas where you are submitting a bid document or a tender document and there are clauses that say all the intellectual, all the IPs will belong to the client, especially with government?
Mm-hmm. You see, that's my gripe with public sector, and that's why I specifically mentioned them. It's because they like doing that. But remember, most of these documents are standards. No one has thought about it. You must scratch that part and you must initial next to it. Nobody should own your intellectual property before they could actually compensate you for it. There is no reason for that. You have developed that intellectual property. It is yours by law until such a time somebody compensates you and buy it from you on certain terms that you accept. Then you can transfer that intellectual property to them. I mean, imagine if somebody owns that intellectual property whilst you bid, it means you can't bid anywhere else. Ultimately, that is the consequence. And if you think about it, they're taking away your right to trade. So that provision is unconstitutional on its own if it would be broadly looked into. So all I'm saying is that scratch that part, initial next to it. Probably no one will read it, by the way, in government, but it's your duty to actually protect yourself against unfair terms. And you remember, if you look into the Consumer Protection Act, there are certain parts where small businesses are treated as consumers, specifically where they've got a turnover under 2 million as it stands, and it gets reviewed by the minister from time to time. But when you are dealing with gigantic companies or bigger businesses, obviously, when it comes to unfair terms, you become a consumer. But you must understand that government as a monster, that act doesn't apply to them because government is the law unto themselves, so to speak. So I need you to be careful whenever you deal with the public sector.
Yolelwa, one more question?
Yes, ma'am.
Okay, so if anyone has a question, I think we can take one more.
Wait.
Just remember to unmute yourself if you'd like to ask your question, or drop it in the chat box.
Hi, I've got a question.
Yes.
Okay, so Yolelwa, if I subcontract somebody and they work for me, they render a service for me, and I compensate them, does that mean I now own that IP? So they delivered a service, they wrote me a report to send to my client. Does that mean that I own that IP now?
There needs to be specifics. In any contract, there must be specifics. If somebody is a subcontractor to your company, doesn't mean you own the things that they render to you, because those people are in business. Remember, and I think this is the most important thing about the right to trade. And if that right is a constitutional right, you've got a right to trade. So if somebody takes away your intellectual property that you trade with, that right is adversely affected. So you can't just generalize that if you're a subcontractor to me and you give me this service, I own the intellectual property. You need to specify which one have you compensated him for this particular project. But that is very, very rare that somebody, when they subcontract for you, you therefore get the right to own their intellectual property. It is very rare because it borders around the lines of being unlawful, because you're taking the right of somebody to trade. So you'll need to be careful and you'll need to be specific what. For instance, if somebody makes perfumes and they design a scent for you, yes, you can pay for that to own it exclusively. And subcontracting and exclusivity as well is two different things. But there is no assumption that if you subcontract for somebody, you as the main contractor, you actually own their IP. It is not a generic law, let me say. And if it is done through contracting, it needs to be around the laws as well. It must be lawful. And also it must make sense and be specific about the parts that you will own as a main contractor.
Can I ask a question, please? My name is Teko.
Yes, sir.
With regard to having to assist one company to deliver a purchase order financially, when you have either borrowed money on that company's behalf on a mutual understanding without any written contract, Do I have a recourse in terms of now the person has delivered and then they got paid, they're no longer honoring their bargaining power, bargaining side of thing, which is paying the money with an interest on that is agreed on gentleman's agreement? Do I have a legal recourse on that?
Yes, you do. And I think we get many questions about verbal contracts, whether verbal contracts are binding or not. Verbal contracts are binding. They are lawful. The issue about verbal agreements is that it is difficult for you to prove them. But in your case, I would assume that you've got a proof of payment that you made to this person. That is somewhat proof. But definitely you can pursue that matter based on exactly the terms that you agreed upon. But as you know, like I say, those will remain allegations for now until he comes back and reply to your story. And you know, the story will be there and you will say this and he will say that. But the fortunate thing is that you'll be sitting in front of a presiding officer, being a magistrate or a judge. They are trained to determine who's telling the truth in the end, and they will rule. But do you want to go through that? Which is why we are having this conversation, that mitigate that risk by having things written down and conclude the correct contracts. But in essence, to answer your question, you do have a recourse, and that recourse is to issue a letter of demand and subsequently issue summons, as long as you've got proof of payment.
Thank you very much.
Thank you. I don't think we have any, I don't think we have any more time for questions, but Yolelwa, afterwards we can take a few more, perhaps.
Yes, right in the end, I'll be available to address all the questions that we couldn't cover now.
Okay, perfect. Thanks so much, Yolelwa. And now we're going to move over to Marlon.